So thank you all for being here today. Can we go ahead and get started? As you know, my name is Boris Mamluk, and I teach international law courses at the law school. And today I'm delighted to introduce a colleague and dear friend, Dr. Akbar Rasulov, from the University of Glasgow School of Law, who'll be delivering a presentation enticingly titled International Law in the Long 1990s. And to provide a little bit of context for Dr. Rasulov's visit, I want to make three brief introductory remarks. First, I'd like to thank the International Law Students Association, and particularly Razvan Accente and Andrew Solarski in the back, Andrew, for helping to organize this event. I'm very glad to announce that this is the inaugural lecture in our new International Law Speaker Series honoring our late Professor Francis Gabor. And over the next several years, we'll continue expanding the international law programming at the law school, and I look forward to growing levels of student interest, not just within the law school, but across the disciplinary spectrum at the University of Memphis. And I know there are a number of students from other departments. I see some faces, perhaps faculty members from other departments. Thank you so much for being here. Second, I would like to thank the administration at the law school for their support for international law programming and this visit. And third, I'd like to thank Dr. Rasulov for being here. Dr. Rasulov has been teaching at the University of Glasgow since 2004 and currently holds the title of Lecturer in Public International Law. As some of you may know, the University of Glasgow is one of the UK's ancient universities, founded in 1451, and is the fourth oldest English-speaking university in the world. I first met Dr. Rasulov through a project of the Institute for Global Law and Policy at Harvard Law School almost 5 years ago. And since that time, I personally have benefited tremendously from his research. As the title of his talk today suggests, it is impossible to understand the dynamics and trajectories of international law without understanding the history of the discipline, particularly in the critical period following the collapse of the Soviet Union 20 years ago. But perhaps more importantly, the title of his talk begs the bigger question: how can we craft a historical sketch drawing on elements of international legal theory, history, philosophy, and critical social theory that is both accurate and yet does not plunge us to the depths of despair as we understand how violent and unruly the world truly is? I think we'll agree that with developments in the world, from Syria to the Arab Spring to the continuing war in Afghanistan, all of them cannot be understood apart from the recent historical context from which they arose. And in this sense, a lecture on the way that we write histories of international law could not be more timely and relevant for us today. Please join me in welcoming Dr. Rasulov.
Is this on? Thank you very much, Boris, for such a flattering and frankly embarrassing introduction. Thank you. It is said one should never start with an apology, and so I'll start with a disclaimer. In preparing for today's presentation, I've been confronted with a rather unenviable task of having to condense what in effect is a 300-page monograph worth of material into what essentially is a 5,000-word paper. I'm not sure. Is this better? Okay. Can you hear me now? Right. So as I was saying, in preparing for today's presentation, I was faced with the rather unenviable task of having to condense what in effect is a 300-page monograph worth of material into what essentially is a 5,000-word paper. And I'm not, frankly, very sure what impact the inevitable sacrifices this has led to in terms of content may have had on the coherence of the resulting argument. But with your permission, I propose that we find out. And so to begin with, a few introductory remarks to help explain the nature of the project that I'm going to talk about today, its basic context, and the underlying aspirations. The paper that I'm going to present now is essentially a brief critical digest of a book that I have spent an awfully long time writing and an even longer time wishing that someone else wrote in my stead so I could just sit back and enjoy finding holes in his argument. Unfortunately, no one proved to be quite so reckless or arrogant, and so here I am. The book, like the presentation today, is entitled International Law in the Long 1990s. And except for the concept of the long 1990s, which I'm going to try to elaborate on in a few minutes, the title, I think, should be quite self-explanatory. This is going to be a work of contemporary legal history. What it tries to achieve, in other words, is to discover the various deep-seated patterns in the construction of the international legal architecture that took shape in the not-so-distant past, and which, with some luck, if excavated properly, could perhaps help us understand, however partially, how the international legal system which we find around ourselves today came to be, how it came to take that particular shape which it has, or in other words, how we, as a discipline and a profession of international law, have got to where we are today, and what all of this means for where we are heading tomorrow. But this description, of course, is correct only on some level. If you want to put it this way, it is correct at the level of the most immediate theoretical ambition that this project tries to pursue. On another level, more profound level, the vision which drives this project forward is a little more complex. Any study of history, and above all, a history that is so recent it still feels alive in our memory, can never remain a self-contained analytical affair, in the sense that it can never keep strictly within its formal cognitive mandate. And the reason for this, I think, is very simple. It is that the knowledge which such kind of inquiries seek to obtain is not ultimately, as the French philosopher Louis Althusser would say, an innocent knowledge. By deciding how we approach our past, and I use the word decide here in a very loose sense, we determine not only what place we assign to ourselves in the stories we tell about our past, but also what community, and therefore what political vision, we thereby become a part of in our present. When I say political vision, the concept of politics that I have in mind is not the standard concept used in the everyday discourse, but rather the more general one alluded to by Roberto Unger in the, and I'm not sure at this stage if the handout has been distributed. Okay, in the second excerpt in the handout paper that hopefully will circulate shortly. So by deciding what sort of relations, practical and passionate relations of production and distribution, acceptance and contestation, forgiveness and trust we want to achieve, we come to write the histories that we want to read. And when it is a history of law that we aim to relay, these actions of acceptance and contestation furthermore inevitably acquire a certain normative flavor. By virtue of international law's inextricable connection with the concept of sovereignty, any inquiry into the course of international legal history is inevitably bound to become also an inquiry into the genealogy of contemporaneous sovereign practices, that is to say, the evolution of the currently dominant forms and modalities of global governance. What is more, if it is an inquiry also that targets a horizon of events that is so close chronologically to its own vantage point, then precisely for the same reason that I have mentioned before, it is also bound to become, regardless of how ready we are to admit this fact, a performative statement about the fundamental makeup of the internal ideological landscape of the international law profession. And so the argument that I want to present to you today is not only going to be an argument about a particular period of international legal history, but also, in a certain sense, an argument about the genealogy of the currently dominant paradigm of global governance, as well as an indirect statement about the essential operative structures of international law's interdisciplinary ideology. And when I say ideology in this context, I use that word simultaneously both in its more traditional sense as the designation of what otherwise might be called false consciousness, That is to say, a certain structure of deliberately sustained misrepresentations and belief systems perpetuated in the service of a particular political agenda, and in the more specifically Althuserian sense, as a particular kind of social practices which result in the molding and constitution of our social identities, in this case, identities as international lawyers and scholars of international law, by way of creating the necessary material conditions for the operation of this belief system. And the basic difference between these two meanings, of course, is that while in the one case, what we're looking at would essentially be a system of loosely interlinked master narratives and plots, in another case, what we're working with, in contrast, is a fundamentally sociological phenomenon. And the reason why I am interested in attracting your attention to both of these meanings is that, firstly, the theoretical movement from the first to the second meaning, to my mind, essentially mirrors what quite possibly was one of the most important methodological transitions in the history of critical thinking, namely the progression from the young Hegelian critique of religion, which was centered around the idea of ideology as the misrepresentation of reality, to the Veblennian/old institutionalist critique of social organization, which was based around the notion of ideology as an active constituent element of that very reality. And of course, these two genres of inquiry are in some sense entirely different from one another, and so by keeping both of these meanings on the table, we risk introducing a rather considerable measure of analytical confusion into our argument. But on the other hand, by taking this risk, I believe we also gain the opportunity to uncover a much greater range of critical insights into the history of our profession than we otherwise would. And that price, I think, is not at all insignificant. The second reason why I would like us to bear in mind both of these two different senses of ideology is that, quite frankly, I think it would be simply impossible for us to try to understand the internal ideological landscape of any given group of people, let alone one that has such a complex collective psychology as the international law profession, without providing a simultaneous account both of the various sets of ideas, doctrines, and belief systems that are shared among the members of that group and of the actual social practices that occur among them, which enable and condition the crystallization of these belief systems. Okay, so that's the basic background and the context behind what I'm going to talk about now. And so to begin with, what exactly do I mean by the long 1990s? Now, the assumption with which I initially started out, my basic hunch, if you will, was that essentially I would use this concept to describe the early years of the post-Cold War period. The period in the evolution of the international legal system, in other words, which started roughly sometime around 1989 and continued more or less until just after the turn of the millennium. And the underlying idea there was that something very important and very fundamental had changed at the beginning of this period in the organizational structure of global governance, as a result of which the operative dynamics of the international legal system, broadly so conceived, evolved during those years into something completely different compared to what it had been before. And no less importantly, a very similar transformation, a very similar developmental rupture, if you will, then happened again in the early years of this century. And so my task, as I saw it initially, was to try to grasp the essential logic of this transformation and these two ruptural events. And to achieve that goal, I thought one of the first things I had to do would be to establish, on the one hand, the formal legal expression of these ruptural events, and on the other hand, to determine their exact temporal parameters. But that, of course, proved almost immediately completely impossible. Because, as every student of history would tell you, chronologies are something that we construct conceptually as a delayed consequence of choosing the particular object of study that we study. They are not something with the help of which we can identify or even clarify this object in practice. To put it differently, the flow of time, especially when we are dealing with such abstract institutional processes as global governance, does not come to us with any pre-attached classificatory labels. It is only after we decide on the identity of the specific process that we want to study, that we can begin to work out how it might be possible to carve out its immanent rhythms and measurements, or in other words, how to identify its indigenous chronology. Which, as you might have guessed, makes the enterprise of international legal history that little bit more challenging. To put it somewhat schematically, before we can determine how far things that we want to study have changed, we have to establish first against what temporal scale we ought to measure this process of change. And we can only know what that scale may be after we have decided the basic configuration of those things that have changed. Because deriving this scale by any other means will ultimately take us nowhere helpful from the point of view of doing legal history. It will only leave us with an essentially arbitrary investigative framework that is parachuted into an environment to which it is not in any sense organic and whose immanent rhythms and measurements it therefore does not and cannot reflect. Which, of course, is not in itself a problem. Hundreds of legal historians all over the world constantly implement this protocol on a daily basis. Hundreds more have done this in the past. And, well, you might say if it was good enough for Hegel, it should be good enough for us. Except that it was not something that I felt interested in doing in this project. Not least because the knowledge that I thought could be thus obtained about international law was not, to my mind, really a knowledge of the specific reality of international law. That is to say, the account of international law's evolution that we would be able to work out according to this protocol of knowledge would not be, to borrow a term from social anthropology, a sufficiently emic account. Which again is not in itself really a problem, except that I decided that for the purposes of this project, it was. And to cut a long story short in terms of what this did to me, that decision cost me the better part of 5 years. It was not a very enjoyable 5 years, but it was a very intellectually rewarding period. The reading list that I went through introduced me to insights and challenges I didn't even know could be made. I don't want to bore you with too much detail about those reading lists, so let me just say, for the proper historians amongst you, that the solution to which I eventually arrived, the answer which I think should be given to the question of how we should organize the study of international legal history as a species of legal history, came to me for the most part from a combination of the following three theoretical vehicles. Firstly, Reinhard Koselleck's concept of modernity as a radically novel type of temporal experience, as elaborated in his book, The Practice of Conceptual History. Secondly, Louis Althusser's theory of the non-linearity of the time of economic production, as elaborated in Reading Capital. And thirdly, and I can stress intensely enough how much of my thinking about international legal history has been built on this particular foundation, Carlo Ginzburg's adaptation of Erich Auerbach's idea of the Ansatzpunkt. And the three most important insights that I took from each of these sources were, first, the notion of the historical non-simultaneity of otherwise chronologically simultaneous temporal sequences. Secondly, the idea of a temporal sequence that can only be constituted in its concept. And thirdly, the basic epistemological conditions under which we can gain access to such sequences. Okay, I'm going to return a bit later to the question of how do we grasp the indigenous rhythm of international legal time. For now, let me just add one more thing. The decision to name the period that I was studying, the long 1990s, was obviously modeled in large part on Eric Hobsbawm's concept of the long 19th century. Just like the long 19th century that Hobsbawm wrote about as an economic historian ended up in his work covering a temporal stretch that extended far beyond the calendar 1800s. So too, the idea of the long 1990s that I was thinking about as an international lawyer, from the point of view of international law's internal momentum, found its respective starting and ending points quite outside the calendar decade of the 1990s. What were those starting and ending points? Both of the boundary lines that I came to identify for the long 1990s, I must say, turned out in the end to be a little fuzzy and somewhat unfocused, which may perhaps be more the result of my failings as an analyst than anything else, although I hope it is not the case. Just to give you a general point of reference, my basic claim about the chronological identity of the long 1990s in international law is that both the beginning and the end of this period expressed themselves in the medium of international legal history through events that were markers of what one might otherwise describe as structural absences rather than actively visible events. The first such absence was a combination of two rather curious patterns. First, the lack of any immediate outbreaks of intense international violence in the aftermath of the end of the Cold War. Second, the concomitant failure to bring any kind of significant reform to what over the course of the preceding half-century had been universally recognized as the standard paradigm of international organization. That is to say, the late Westphalian paradigm populated by territorially organized statal entities controlling the terms and conditions of the broader international intercourse by means of intergovernmental diplomacy as channeled, in the last instance, through a structure of interactional patterns modeled on the classical doctrine of sources. The fact that this failure to reform happened alongside what almost immediately was acknowledged as an irreversible shift in the formal grammar of all standard geopolitical processes was what, in my mind, ultimately clinched the deal. But wait a minute, you might say at this point. If it is truly the case that sometime around 1989 there had been this fundamental rupture in the development of the international legal system, where are the corresponding signs in the register of the international institutional reform? Why was there no new universal international organization established like there had been after the First World War and the Second World War? I mean, you have a fundamental and very rapid change in the logic of international practice and the distribution of the international balance of power, and yet no comparable transformations can be observed in what would be traditionally considered the center stage of the international legal reality. What is going on here? And the answer, I think, is something very similar to what Thomas Kuhn used to call paradigmatic shifts. The change in the generative structure of the international legal intercourse introduced at the end of the Cold War has turned out, in fact, to be so far-reaching and so profound that what over the course of the preceding 5 decades had been virtually without exception considered the governing framework for the organization of international relations was summarily discarded and quietly let fall into desuetude overnight. As those of you who have done a course in public international law will know, despite the almost universally acknowledged fundamental reorganization of the international balance of power, which took place in the early 1990s, no notable changes of any kind had been introduced either into the formal architecture of the United Nations regime or in the governing principles of the international law of personality, international treaty law, or indeed, for that matter, with a few very modest exceptions, the law of jurisdiction and responsibility. And all this, as even every scholarly commentator worth their realist salt kept trumpeting from each commanding height and corner, the unprecedented rise to preeminence of the so-called non-state international actors, the proliferation of the so-called soft lawmaking processes, and the explosive disintegration of the old billiard ball model of statehood into the ever more fragmented bundles of competing functionalities and competencies. The old customary international law regimes, so painstakingly constructed by the previous 3 generations of international lawyers, proved, in other words, to be so ill-adjusted to the systemic demands of the new development that none of them even got updated or refitted. Even though if we look at their earlier histories, even the briefest glance back would be enough to confirm that each of these regimes was being constantly reformed over the course of the previous several decades. Now, it is obvious that the full scale of this sort of rupture could not register right away. As time went on, however, teaching the core regimes of international law, such as, for instance, the law of treaties or the law of persons, started to become an exceedingly simple task. Because as it turned out, on closer inspection, the organizational fabric of these regimes pretty much had stopped evolving. Now, if we recall that international law, like every other kind of law, is ultimately a tool of social engineering, what would be the first thing that we would typically expect from any piece of technology in times of great change? Either a pattern of extensive upgrading or dereliction. Horse carriages stopped evolving after the advent of car travel. VCRs stopped getting perfected and upgraded after the DVD technology took off. Mind you, neither the ones nor the others got eliminated or destroyed overnight. They just fell into gradual disuse. Their evolution froze, and slowly they got left behind. Now, if we look at the early 1990s, it seems to me that a very similar pattern could be observed with regard to what in the previous several decades would have been considered the central core of the public international law regime. Like the old shipyards on the south side of Glasgow, they never found anyone interested or committed enough to try to redevelop and reinvent them. Instead, they just got abandoned and allowed to remain as they were. And that, if you think, is a huge thing for us as lawyers. Because the one thing we know as lawyers, of course, is that you never allow a legal regime to remain as it is. Lawyers don't do the late Beatles philosophy. We always tinker with the law. We never let it be. And yet here we are. We left international law be the way it had been. We left international law of treaties remain almost completely unchanged, more or less since the mid-1980s. The same goes for the law of jurisdiction. If you leave aside the question of international criminal responsibility, the same goes for the law of responsibility. Chapters on the law of international personality in the leading international law textbooks have remained pretty much unchanged and unamended, both in their structure and their content since the early 1980s. Sources, persons, powers, responsibilities, none of these fields have seen any growth since the 4th edition of Brownlee. How can this be? And the answer to this, as you might have guessed, is not because international law had stopped evolving as a system. The evolutionary momentum went on quite energetically, in some cases even at breakneck speed. It's just that its locus within the system had shifted completely. The heart of the international legal regime, and thus the architecture of its organizational core, moved elsewhere compared to where it had been before. And it remained within that elsewhere all throughout the subsequent decade, until the next, similarly half-invisible structural recalibration took place. Compared to the earlier ruptural moment, this one had a relatively more recognizable material expression. The decade of the long 1990s in international law ended more or less around the time after the UN Security Council Resolution 1368, which for the first time in the history of the United Nations explicitly recognized the applicability of the traditional right of Article 51 self-defense against unincorporated non-state actors, which crucially, furthermore, failed to attract any observable protest from the rest of the international community as a matter of formal legal claim. The other, perhaps less obvious formal markers of the onset of the new era included what to all intents and purposes appears to have been an official abandonment of the structural adjustment theory by the International Monetary Fund in September 2002, and the gradual rise over the course of the next 3 years of what Akil Mbembe, the South African social theorist, so evocatively dubbed necropolitics as the new governing model of the international law of war, especially in areas of low-intensity armed conflict. But that is a subject matter that would be more suited for a different kind of inquiry. In this talk, I want to focus on the history of the long 1990s. How do international lawyers typically remember the long 1990s? One standard reaction, whose formula it seems was established already in the early years of the new century, is unapologetic nostalgia. A good illustration of it can be found in an address delivered to a group of academic law librarians some time after the 9/11 events by Harold Hongju Kaw, the then recently retired Undersecretary of State in the Clinton administration and the soon-to-take office Dean of the Yale Law School. The post-Cold War era, declared Professor Kaw, and I quote, began in November 1989 with the collapse of one structure, the Berlin Wall, and ended on September 11th, 2001, with the collapse of another, the World Trade Center. Between these two collapses, we have passed almost literally out of the light and into the dark side of the age of globalization. When we look back, we will probably remember the period from 1981 to 2001 as the age of global optimism, and the post-September 11 period as an age when global pessimism began to prevail. End of quote. Now, ignore for the moment the uncharacteristically eschatological tone of the middle part of the passage. Focus instead on the last sentence, the last part of the quote, and the rather strange set of assumptions it seems to suggest informed Professor Koh's memory of the decade. To what extent was the long 1990s really an age of global optimism? Not many people around the world, it seems, would probably share that view. Looking at that part of the world where I come from personally, most ordinary Tajiks and Chechens, it seems safe to say, would beg to differ, having endured several long years of civil war during that decade. So also most definitely would most Rwandans and Bosnian Muslims. For all the wealth of writing that has been churned out by the international criminal law industry about the Bosnian and Rwandan genocides, their stories of what the long 90s had been all about still remain to be heard, as do, of course, the stories of the so-called Russian settlers in Latvia and Estonia, who, following the abrupt dissolution of the USSR, suddenly found themselves overnight stripped not only of all meaningful political rights, but also of the right to acquire property by being effectively debarred from joining the newly launched privatization program, just as their states triumphantly marched down the road to EU membership. Casting our gaze in a somewhat different direction, it seems safe to say the cotton farmers in Mali and the coal miners in South Wales did not probably find that much room to feel very optimistic during this period either. Nor did, of course, the shipyard workers in Hamburg and Glasgow. Nor, for that matter, the thousands upon thousands of ethnic Crimean Tatars who tragically slipped through the cracks of the new post-Soviet nationality laws as they began to return from their exile in Central Asia to their historic homeland in what is nowadays a part of Ukraine. Did their world indeed become a lot flatter during the long 1990s, as Thomas Friedman of the New York Times fame once famously suggested? Chances are that it probably did, just as it did for the hundreds of thousands of agricultural workers in Eastern Europe after their states began joining the World Trade Organization. The only tricky part there, however, was that just as it had become a lot flatter, so too their world also had become a lot more tilted and unstable. And whatever old institutional mechanisms might have existed that would have made this newly created incline less dangerous and slippery were now put into rapid dismantlement. So once we consider all these examples, the proposition that the long 90s should be remembered now as global optimism seems rather striking in the shockingly narrow selection of its memory base. But it is certainly a very revealing proposition that tells us a lot about how the international law profession lived its part of the decade. Another common motive that I think characterizes profoundly the way in which the international law profession today tends to remember the legacy of the long 1990s comes through in the countless celebrations of the so-called global human rights revolution. In its standard formulation, this memory of the decade presents itself essentially as a realization of some vulgar Kantian daydream. The long 90s is remembered here as the age of the triumphant breakthroughs in the age-old journey for the global recognition of fundamental human rights standards and the universal spread of democratic freedoms. Susan Marks and David Kennedy have shed a very interesting light in The Riddle of All Constitutions and the Dark Sides of Virtue on the kind of mindset that would typically feel compelled to interpret international law's achievements during this decade in this light. And Samuel Moyn, for his part, has shown us just how fast this mindset had entered the international professional consciousness. But I will not go through those arguments now. Instead, let me share with you a couple of passing observations and another quote, which, as it happens, also comes from a public address delivered by a prominent international law practitioner and diplomat, which seems to me to open a rather interesting perspective on what this whole human rights revolution dynamic actually gave the international law profession. So first, the observations. Looking at the broader context of what happened to the international human rights regime in the immediate aftermath of the end of the Cold War, it seems to me, first of all, rather weird that the most lasting image that has been retained in the disciplinary memory about that period would be the image of the progressive advancement down the road to an ever-widening recognition of fundamental human rights standards. It seems weird to me because, firstly, most of those expansionist trends that reached the international human rights regime in the 1990s received their original impulse from a much earlier era. If there had ever been anything like the golden age in the history of international law's interaction with human rights, surely it would seem to be that it was the decade of the 1970s. In the second place, the single most important trend that, to my mind, captures the spirit of the epochal interaction between the project of international legal regulation and the enterprise of human rights advancement over the course of the long 1990s did not, in fact, find its most immediate expression in the medium of human rights law, but rather in the field of the international law of armed conflict. And I'm talking here of the breathtaking rehabilitation of the age-old villainous doctrine of humanitarian intervention. After configuring itself for nearly 2 centuries in the language of exceptional measures and system-threatening extraordinary rights, the discourse of humanitarian intervention as it developed in the long 1990s suddenly began to shift its articulatory patterns towards the language of system-compliant duties and perfectly routinized enforcement structures, just as it discovered the immense ideological potential opened up by the emergence of the doctrine of the responsibility to protect. And what a successful shift it was. Where the previous generations of humanitarian interventionists had consistently found themselves locked into fundamentally counterproductive master narrative built around a motley of idealized higher law tropes and a very contradictory concept of sovereign prerogatives, the new international lawyers found at their disposal an extremely coherent theory of humanitarian warfare that was grounded in a freshly recalibrated concept of national sovereignty as an active regime of duties rather than rights, and an idea of war as an essentially routinized police action rather than an act of global diplomacy. Naturally, none of these transformations would have been conceivable under the old bipolar model of international organization, for indeed it was only under the climate of a newly reinvigorated system of global security that the idea of treating war as a form of apolitical enforcement action became possible. But that is, of course, a very obvious point. What may not be so obvious is the impact which these transformations had on the general character of the structural relationship between international law and the project of human rights, which, as I see it in a nutshell, essentially came down to the conversion of the discourse of international humanitarianism from a field of abstract macro-level policy discussions to one dominated by an increasingly technocratic talk about what would be the most efficient techniques for the implementation of global communal will. Okay, so much for the observations. Let me move now to the quote which comes in this instance from the former Dutch Minister for Foreign Affairs, and at the time he made the statement, the OSCE High Commissioner on National Minorities, Max van der Stoel. And here's that quote. Protection of the rights of persons belonging to national minorities is now seen as a reflection of a country's willingness and ability to live up to its international commitments. The way in which a country acts towards its own people is a good indicator of how it will act with its neighbors and in the international community. This point is kept in mind by the European Commission when considering accession, and by the Council of Europe, which is constantly insisting upon respect for human rights among member and prospective member countries. End of quote. Now, if we take a step back and think about the patterns of van der Stoel's reasoning, I think it is quite striking to observe that a little more than a century earlier, the two main assumptions at the heart of his argument, the view that the way in which a non-European state which wants to join the European circle treats its national minorities can be used both as a predictive factor for forecasting its future behavior in the national arena and as a chief criterion for assessing its readiness to assume membership in the global community of nations, had been commonly known under the rubric of the doctrine of the standard of civilization. Because the common view today about what the doctrine of the standard of civilization had stood for in the late 19th century international law is that without a doubt, it marked the highest peak of turning racism into the bedrock principle of international law. The fact that at the end of the 1990s, this way of thinking and speaking about international law found its way back into the official discourses of the international community, and did this, moreover, through the instrumentality of the concept of international human rights, I think shines a very troubling light on the evolution of the international legal system in the post-Cold War years. And yet, what exactly was the logic of this evolution? Let me start answering this question by listing a few brief points about the basic context which structured the operation of the international legal system during the long 1990s. Think of this, if you will, as a list of over-determinational trends or the background conditions of the institutional dialectics of the epoch. The label does not matter so much as the referent. There were 10 main trends which I think we must take into account whenever we analyze the evolution of international law during the long 1990s. First, the rapid spread of high finance capitalism across the whole surface of the globe in the wake of the sudden disintegration of the Eastern Socialist bloc, commonly misacknowledged under the protean rubrics of economic globalization and the end of ideology. Second, the rise of a whole new network of pan-European organizations and their associate and subordinate institutional structures, and the initiation of the corresponding enterprise of juridical pan-Europeanism, manifested not least in the development of the doctrine of a common acquis. Third, the reinvigoration following the end of the Cold War of the United Nations collective security process and the branching out of the UN human rights architecture, including the creation of the post of the UN High Commissioner on Human Rights and the systematic self-conscious human rightsization of all UN discourses and programs. Fourth, the growth in size and the increasing sophistication of the Bretton Woods institutional architecture and the expansion of its lending and technical assistance programs into the former Soviet bloc. Fifth, the politico-institutional rejuvenation and, to some extent, reinvention of the old NATO alliance, not least as evidenced by its policing campaigns in the Balkans, its elaboration of the Partnership for Peace scheme, and its punitive actions against Yugoslavia in 1999. Six, the continuous expansion of the European Union from the 1980s model of a European economic community into a post-Amsterdam Treaty neoliberal fortress Europe, followed by the projection of a European monetary union without any parallel institutionalization of the old union structures in the areas of foreign policy, fiscal policy, and social welfare programs. Seventh, the root and branch reinvention of the international security paradigm on the basis of the OSCE-inspired comprehensive security model, exacerbated by the parallel decoupling of the formal political and substantive economic dimensions of the national sovereignty processes, especially as evidenced in the countries of the Third World, and reinforced by the concomitant migration of the locus of economic decision-making into the politically unaccountable, organizationally under-institutionalized, semi-private transnational domain. Eighth, the popularization and rise in prominence of the practices of allegedly neutral technocratic judgment passed on the lower-tier geopolitical units by regional and global hegemonic powers, inter alia, through the instrumentality of corruption indexes, security analysis briefs, and human rights and development reports. Ninth, the rapid institutionalization of the practice of international expert missions and its systematic expansion into areas as diverse and dissimilar as banking, public health, policing, secondary education reform, followed by the swift expansion and rise to prominence of the so-called watchdog and whistleblower functions of the transnational civil society, generously financed and staffed by the governmental and semi-governmental circles associated with various regional and global hegemonic powers, and the increase in attention formally given by these powers, as well as the international public organizations to the judgments issued by this watchdog and whistleblower component of the transnational civil society about the past, present, and future of foreign governments and societies lacking any history of indigenous liberal capitalism. 10th, the historical transformation of the modern warfare patterns away from large-scale conventional wars in the direction of low-intensity guerrilla conflicts, accompanied by the parallel intensification of technological progress, especially in the area of mass telecommunications, and the almost universal defeat of the traditional left project in the industrially advanced world, as exemplified not least in the continuous drift of the traditional center-left parties towards increasingly right-wing political and economic agendas. Okay, so that is the basic context. But of course, as you may have gathered from my earlier remarks, getting the context in this sort of inquiry is far from everything. What we need, now that we have a general sense of what was happening outside the immediate plane of the international legal system, is to get a sense of the specific internal trajectory of that system taken as such. That is to say, approached according to its own organic logic rather than just as an object effect of the dialectical interplays occurring among other elements of the global governance superstructure. What we need to find out, in other words, is what would be the most reliable window into the internal systematicity of that process so that we can reconstruct the general logic of international law's evolution in the 90s. And the best way to go about this task, as I said earlier, I think comes from the work of Carlo Ginzburg, in particular his revision of Erich Auerbach's idea of the Ansatzpunkt. Now you can see what Auerbach himself had to say about this concept in the 4th section of the handout. Let me just point out briefly what I think are the two most important features of the Ansatzpunkt methodology. Firstly, in order to accomplish any kind of productive theoretical synthesis, that is to say, in order to capture the essential meaning of something as abstract as an epoch, the Ansatzpunkt that is chosen needs to be very concrete and well circumscribed, as well as to have what Auerbach calls a certain radiating power, which allows it to bring in metonymically the larger problematic of the historical period. Secondly, the practice of working towards this kind of synthesis is not, strictly speaking, theoretically grounded in the idea of trying to grasp the whole on the basis of its most general or common features, since the concept of the Ansatzpunkt does not have any statistical dimension, nor on the basis of any kind of pre-existing categories, since the logic of the Ansatzpunkt is ultimately that of an internally supplied material specificity. What is being studied, says Auerbach, should speak for itself. It has to be as concrete and circumscribed as possible, for that is indeed the only condition under which the background whole can be grasped in precise and objective terms. And thus we arrive at last at the central question. What should be our Ansatzpunkt for the study of the international legal system in the long 1990s? Contrary to the traditional scholarly practice, which tends typically to answer this question by turning variously to the fields of international trade law, human rights, or jus ad bellum, I have come in my work increasingly to focus on what might be called the international legal regime relating to the treatment of national minorities, or to use a perhaps slightly cumbersome acronym, ILTNM, International Law Relating to the Treatment of National Minorities. What is exactly ILTNM? And is it essentially the same thing as the International Law of Minority Rights? The answer to the first part of the question is, it is a thematically constituted regime at the heart of which lies the idea that international law should have something to say about the way in which states typically treat their national minorities. The answer to the second part of the question is, in a nutshell, no. To be sure, the relationship between the two legal regimes is a very close one, and there definitely seems to exist a certain measure of overlap between them. However, both at the conceptual and at the substantive levels, the two entities are not identical, and there seem to be several very good reasons for why we should retain the state of affairs. To put it perhaps somewhat schematically, it would be possible to identify numerous elements in the contemporary ILTNM regime which do not derive from norms concerning the protection of minority rights. Similarly, it would be possible to identify numerous parts of the International Law of Minority Rights which have very little to do with the ILTNM. One of the best ways to understand how and in what sense this might be so would be to recall the classical distinction between what might be termed minorities as positive associations, or in Sartrean terms, minorities for themselves, and minorities as negative associations, or in Sartrean terms, minorities in themselves. Or to use a slightly more accurate description, minorities seeking to retain and promote their communal identity, and minorities formed as an object effect of other communities' interethnic practices. The immediate boundary between categories in practice, of course, is almost always going to turn out somewhat unfocused, but the basic idea behind the concept seems to make a lot of sense, especially if we recall the standard patterns of the international legal response to the question of minorities. Thus, for example, it seems rather obvious that it was by and large only the former type of minorities, minorities as positive associations, whose interest the League of Nations was designed to address in the interwar period. Likewise, it almost certainly would be only the latter type, minorities as negative associations, that many contemporary human rights scholars, such as, for instance, Sir Nigel Rodley, would typically have in mind when making the claim that all the standard concerns included under the heading of minority rights can in fact be very easily addressed by the existing body of the general human rights law without formally needing to create a separate category of minority rights. Most of the modern scholarship addressing the question of minority rights, of course, tends to ignore this distinction. The practical organization of the international regulatory project, however, suggests that it shouldn't be so. It is not inconceivable, of course, that a minority group which comes into existence only insofar as its members find themselves constantly discriminated against will, over some unspecified period of time, develop some kind of residual sense of group solidarity. Nevertheless, it seems highly unlikely that this sense of solidarity will then ever transform into, to use the standard phrase from the 90s policymaking vocabulary, aggressive nationalism. And it was, of course, precisely this socio-political phenomenon that appeared to account for most of the policymaking initiatives that swept through the international legal community in the immediate aftermath of the end of the Cold War. To put all this in a slightly different manner, a minority group that has been formed exclusively as a function of the discriminatory attitudes of the majority group would be very unlikely to ever develop into a genuinely coherent ethnic community, in the usual sense of that word. That is to say, in the sense adopted, for example, in the famous Greek-Bulgarian communities case decided by the Permanent Court of International Justice, or somewhat closer to our times, in the work of the UN rapporteur, Francesco Capaturti. The immediate thematic object at the heart of the ILTNM regime is the international regulation of the domestic treatment of national minority communities taken as communities. The immediate object at the heart of the International Law of Minority Rights is the treatment of individual persons belonging to the designated types of minority identities. So far, so clear, but then, as every international lawyer knows, from the standpoint of the traditional international legal doctrine, minority communities have never been recognized as legal subjects in their own right, that is to say, as entities capable of possessing and enjoying international legal rights in their own name. If that is the case, however, the question immediately arises, how can we then reconstruct the actual shape of the ILTNM regime? In the absence of a clearly identifiable subject of rights, what other criterion can be used to help work out the essential structure of the respective legal field? And the answer to that question takes us, I think, to one of the most interesting areas of analytical jurisprudence. Briefly, because we don't seem to have that much time. The concept of the legal regime that I use in this project is centered around the notion of a functionally manifested pattern. The word functional here is meant to convey the idea that the actual legal reality of that pattern will be found not so much at the level of the standard legal positivist phenomena, such as formally enacted legal rules, but rather in the practically realized behavioral reactions exhibited by the respective group of international legal actors. Or to put it in a somewhat different manner, the concept of the law that we're looking at here owes a lot more to the legacies of Savigny, Holmes, and Yering than to the legacies of Kelsen and Hart. The law is all those things which are actually observed in practice, not those which have been so designated in name. Looking from this angle, the idea of the ILTNM regime can consequently be given the following definition. Firstly, in terms of its formal ontological status, the ILTNM is an abstract normative derivation of a socially concretized pattern of behavioral predispositions exhibited by international legal actors. Secondly, in terms of its internal composition, it is a nonlinear pattern. That is to say, it is a pattern whose constituent materials do not all belong in the same analytical register. Thirdly, a large part of what goes into the makeup of the ILTNM can be directly traced on the surface of the formally enacted international corpus juris, such as, for instance, Article 27 of the International Covenant on Civil and Political Rights. But a significant part of it can't. And so the task of identifying the essential contents of this regime will necessarily have to include what in literary theory would be called the enterprise of symptomatic reading. That is to say, the analysis not only of the actual positive contents of the various legal practices, but also the related gaps and silences, as well as to use the famous Holmesian phrase, the corresponding inarticulate major premises. What is more, our methodology in this endeavor, as correctly predicted by Jerome Frank, cannot be simply derived from some vulgar concept of empirical statistics, but rather will have to include a considerable degree of inferential reasoning, which of course is a very inexact form of thought. And so to advance in that task, in anything approaching a formally convincing manner, we would need therefore to adopt a sufficiently consistent protocol of reasoning. In my own work, I have come increasingly to the conclusion that the most effective form of such protocol would be one that includes, as a matter of minimal analytical procedure, the following three principles. First, in the analysis of the actual positive content, we must pay attention to what the available legal materials expressly identify as the principal social problem which requires addressing and amending. We must pay attention, in other words, to how this problem is framed, what immediate solution is formally proposed for it, and in terms of what logical argument this solution is justified. Second, in the analysis of the proposed programmatic vision, we also need to pay attention to what type of institutional mechanism is entrusted with enforcement and realization of this vision in practice, and how this entrustment distributes the bundle of competencies across the international legal community. Third, last but not least, in the analysis of the justificatory logical argument, we also need to pay attention to what overarching goals and values are constantly invoked and made reference to under the rubrics of fundamental principles, inherent rights, but also pragmatic considerations. Bringing all these ideas together now, the following picture appears to emerge. Firstly, the greatest in scope and the most significant in substantive terms advancements in the development of the ILTNM regime during the long 1990s came under the rubric not of the standard hard law international norm-setting procedures, such as treaties or the pronouncements by international judicial organs, but through the activities of such decidedly non-juridical organs as the Organization on Security and Cooperation in Europe, in particular its High Commission on National Minorities, and the Council of Europe Parliamentary Assembly. To put it differently, the main core of substantive regulatory contributions on this front was achieved primarily through the instrumentality of soft law, or which is essentially the same thing, a set of global governance modalities which are fundamentally uncommitted to the idea of preserving the ideology of sovereign consent. Secondly, if we consider, however, the general discursive patterns by which these contributions had been realized in practice, The overwhelming impression will be that, irrespective of their formal status under the classical doctrine of sources, the actual linguistic conventions through which these soft law instruments were enacted consistently remain those most commonly associated with international juridical form. Thirdly, reviewing the patterns of actual empirical compliance equally leaves no room for doubt as to the fact that the practical reception of these soft law instruments by all the parties concerned, which includes not least the community of international legal scholarship, remained that in which in the previous times had been traditionally accorded to hard law instruments, that is to say, the products of the standard Westphalian lawmaking process. Fourthly, as the decade wore on, the effective power structure which underpinned this norm-setting procedure increasingly came to exhibit all the standard traits of the Foucauldian disciplinary framework, replete with its